Hey, this is Trent Cotney with Cotney Attorneys and Consultants, and this is another Cotney Industry Update. I'm going to give you all the legal, HR, and safety news you need to know in less than 5 minutes. So, last couple of weeks have been incredibly busy. We have seen a big uptick in the number of phone calls coming into our office involving OSHA inspections. We've seen a big uptick in both federal, state OSHA plans as well as state plans. And one of the consistent themes we are hearing from contractors and trades is that they didn't know what their rights were. And OSHA often doesn't tell you what your rights are. So it's important that you really pay attention to that. You know, one of the things that we always advocate is, look, if you're a supervisor, if you have supervisory authority, regardless of whether it's a superintendent, officer, director, management, then you have the ability to have not only a member of management present, but also your counsel. Okay, and that makes a big difference. Okay, so if OSHA wants to interview you on a job site and you are a supervisory personnel, you don't have to provide them testimony at that time. Okay, you can provide them testimony at a later time. Obviously, you have a duty to cooperate, always tell the truth, make sure that you're doing everything you can to assist them in the investigation. But you do need to be able to assert your right and have your counsel and your member of management present if you so choose. Along those lines, you want to make sure that you are really thinking about everything the day that it happens, meaning that when OSHA comes out to the job site, you want to make sure that your person out there in the field is prepared, has an SOP in place for an OSHA inspection, knows to call the home office, knows what the rights and duties are during a walk-around inspection, during a closing inspection, and during witness interviews. Okay, working on a second OSHA book. The first OSHA book, OSHA Defense for the Construction Industry, is out now. Second book is going to focus on more rights and responsibilities for all industries, not just construction. I hope to have that out within the next month or so. Next thing I want to talk to you about is HR related. One of the things as we start to see vaccines roll out, I got my first shot yesterday, my arm's still a little bit sore, is employers that are engaging in voluntary vaccination programs. One thing that's very important to note is that you want to make sure that if you are engaging in a voluntary program, that you provide an incentive, not a detriment, meaning you can't withhold pay if someone doesn't get a vaccine, okay? It needs to be voluntary, not mandatory, okay? If you want a mandatory vaccination program, there are other legal issues that come with that. We'll talk about that on a different industry update. But just remember, voluntary, keep it positive. If you want to offer something, offer gift card, offer whatever you might want to do along those lines. Always work with your third-party benefits administrator and work with your HR staff to make sure that you are crossing your T's and dotting your I's, regardless of what state that you're in. Last thing I want to mention is that we as an industry continue to experience volatility in material prices and availability. Okay, we have seen a huge spike in litigation related to this, and we have started to assert in certain cases where it is appropriate what is known as the implied warranty of availability. Now, this is a little known and little used potential claim or defense that says that if you are on a public project, primarily federal government work, that if a material is sole sourced or spec'd and you can't obtain that, then the government has indicated that it is warranted that you could get it and you could potentially be able to recover damages or defeat claims as a result. So classic example, one that we are using it on now, is delay. Okay, the delay was called because the sole source provider couldn't provide whatever they needed to do. As a result, we asserted the implied warranty of availability in a state that had adopted it, and we're using that as a defense to say, look, we're not subject to delay because it's not our fault, and by the way, you warranted that you were going to be able to get this stuff to us. So as always, we will keep you informed of the developments as they occur. Any questions for me, feel free to reach out to Cotney at cotneycl.com. As always, we appreciate you guys. Thank you.